He didn't think of it as a threat when he slid the envelope across the table. He thought of it as a solution. That's the part I keep coming back to, how calm he was, how certain. He'd built an empire on the belief that every problem had a price, and he'd decided, somewhere between his morning espresso and his 10 o'clock call with his lawyers, that I was a problem with a price of $800,000. He was wrong about that. I was 29 when I met his son at a fundraiser in downtown Vancouver. It was one of those events I almost didn't attend. A colleague had given me her ticket at the last minute, and I'd worn the only dress I owned that felt appropriate for a room full of people whose watches cost more than my car. I was a registered nurse at the time, working long shifts at Vancouver General, the kind of person who budgets her groceries and treats a night out as a genuine occasion. I didn't belong in that room. I knew it. But I went anyway, because I was 29, and I was tired of spending my Saturdays watching television in my apartment in Kitsilano. His son, I'll call him by what he was to me, which was the man I loved, was nothing like I expected someone of his background to be. He was funny in a self-deprecating way, genuinely curious, asked me questions about my work and actually listened to the answers. His father owned one of the largest private real estate development firms in British Columbia. His name was on buildings I walked past every week. But his son had grown up, as he described it, with a complicated relationship to all of that. He'd done his own degree, worked abroad for a few years, came back and took a modest position at an architecture firm. He talked about his father with a kind of careful affection, the way you talk about someone you love and also, somewhere underneath that love, are quietly afraid of. We dated for 14 months. I met his mother twice and liked her. I met his father once, briefly, at a dinner where he looked through me the way you look through a window when you're trying to check the weather. Not unkind, just uninterested. I wasn't part of the equation he was running in his head at that particular moment. I became part of it when I told his son I was pregnant. We were in my apartment when I told him. He sat very still for a long time. Then he said he needed space to think. I said, of course. I meant it. I wasn't asking him to drop to one knee. I was telling him something important and giving him room to be a person about it. He left that evening and texted me the next morning to say he needed a few days. I said okay. I was scared, and I was also quietly, stubbornly certain that I was keeping this baby. I hadn't worked out the logistics. I just knew. 3 days later, I got a call from a number I didn't recognize. It was his father's assistant, asking if I was available to meet. She was polite and professional and gave nothing away. I said yes, because I thought it might lead to something useful. I thought maybe his son had told his family, and they wanted to talk it through, the way families sometimes do when the situation is unexpected but everyone is trying to be reasonable. I took the SkyTrain to an office tower in Coal Harbour. I was shown into a boardroom with a view of the inlet that I would have found beautiful under different circumstances. His father was already there. He stood when I came in, which I noticed. He gestured to a chair across from him, which I also noticed. There was a bottle of still water on the table, and 2 glasses, as if we were about to have a business meeting, which, it turned out, we were. He said he hoped I was well. I said I was, thank you. He said he understood I'd had some news recently, and that he wanted to speak with me woman to person. He actually said that, woman to person, as if he'd rehearsed it and thought it sounded respectful. He said his son was at an important point in his career, that there were some significant projects on the horizon, and that he was sure I could understand how certain complications could affect things that were larger than any of us. I said I wasn't sure I followed. He slid the envelope across the table. He said there was a figure inside that he hoped I would find generous. He said the arrangement would be handled discreetly through his legal. He said there would be no judgment on his part. No hard feelings. That these situations arose, and the important thing was that everyone moved forward in a way that worked for them. I looked at the envelope for a moment. Then I looked at him. I said, "And your son, does he know you're here?" His father's expression didn't change, but something behind his eyes shifted. He said his son was a good man who sometimes needed to be protected from decisions that might not serve him in the long run. I said I understood. I picked up the envelope, put it in my bag, thanked him for the water, and left. I didn't open the envelope on the SkyTrain. I opened it in my apartment, standing in my kitchen with my coat still on. $800,000. There was a typed letter with legal language about non-disclosure and the voluntary termination of parental rights claims. There was a line that read, in careful legalese, that the undersigned agreed this meeting had not taken place and that no offer had been conveyed. I set it on my counter and I stood there for a while. Then I called my sister, who lived in Burnaby, and who had always been, in moments of crisis, the most practically minded person I knew. I read her the letter over the phone. She was quiet for a moment, and then she said, "Don't sign anything, and tomorrow morning call a family lawyer." I didn't sleep much that night. I thought about the $800,000 and what it would mean, the student debt it would clear, the down payment it would make possible, the years of financial pressure it would erase. I thought about my own mother, who had raised my sister and me after our father left when I was 7. I thought about what she'd said once, when I was in my early 20s, and asked her if she ever regretted how hard it had been. She'd said, "I never regretted you. I only ever regretted the people who made it harder than it needed to be." I thought about that for a long time. In the morning, I called a family law firm that a colleague had mentioned once, the kind of firm that handled high-conflict cases. I was seen the following afternoon by a family lawyer, a woman in her early 50s with an unhurried manner and a habit of taking notes in a small green notebook while I talked. I told her everything. She asked me several precise questions. She asked whether I was certain about the pregnancy, about the timeline, about whether I had documentation of the meeting with his father. I said I had the envelope and the letter. She asked whether the letter had been signed by his father or anyone else. I said no, it was for my signature only. She wrote something in her notebook and then looked up and said, "That envelope is evidence of a very serious attempt to interfere with your legal rights and your child's legal rights. In Canada, a father cannot waive paternity obligations simply because his family finds the situation inconvenient." She explained the federal child support guidelines. She explained that in British Columbia, child support is calculated based on the paying parent's gross income, using a table that applies across the country, and that for high-income earners above $150,000 annually, courts retain discretion to assess support beyond the table amounts. She said that given what I'd told her about his son's income and, more importantly, about assets that might be attributed to him through family arrangements, we would be building a thorough picture. She said, "What would you like to do?" I said I wanted to establish paternity and file for support. I said I also wanted to preserve everything related to the meeting in Coal Harbour. She nodded like I'd said something sensible, which I suppose I had. That same afternoon, she instructed a legal courier to deliver a document package to the downtown office address. I had given her his son's full name and his workplace. I found out later that the courier arrived during a team meeting and the receptionist had to bring the envelope in. I try not to feel any particular satisfaction about that. I mostly succeed. I didn't hear from his son for 4 days after the documents were served. When he finally called, he sounded like someone who had been in several difficult conversations already and wasn't sure this one would be any better. He said he hadn't known about the meeting with his father until after I'd left the office. I said I believed him, which I did. He said he was sorry. I said I knew. Then we were both quiet for a while, and I said, "I'm not doing this out of anger. I'm doing this because your child deserves to be recognized and supported, and so do I." He said he understood. His father's lawyer sent a letter to my lawyer within the week, written in the kind of language that is designed to seem reasonable while quietly implying that the opposing party is being unreasonable. It questioned the timeline of the pregnancy. It raised the possibility of a paternity dispute. It suggested that my client might wish to consider the practical realities of extended litigation and the emotional toll of contested proceedings. My lawyer sent back a 1-page response that I read 3 times because it was so clean. It noted that prenatal paternity testing through non-invasive methods was available and that we were prepared to proceed. It noted that the attempt to offer compensation in exchange for non-disclosure had been preserved in its original form. It stated clearly that we intended to proceed under the Family Law Act of British Columbia and that we were prepared to do so in any forum that served the best interests of the child. She told me afterward that the mention of the envelope tends to change the temperature of these conversations. She was right. His father called my phone directly 2 weeks later. I don't know how he got the number, though I suppose a man with his resources doesn't find that particularly difficult. He was less measured this time. He said I was making a mistake. He said his son's career and reputation were at stake. He said there were ways this could become very complicated for me professionally and personally. He didn't say anything that was quite explicit enough to be a direct threat, but he said enough that I held my phone away from my face for a moment and looked at it like I was seeing something clearly for the first time. I told him I was going to end the call now and that my lawyer would be in touch. I told my lawyer about the call the same day. She added it to the file. She said, "Document everything. Keep every message, and do not speak to him directly again. I was 29 weeks pregnant by the time we had our first court appearance. I wore a blazer I'd borrowed from my sister because I didn't own one that still fit properly, and I sat in a waiting room at the BC Supreme Court Family Division in downtown Vancouver and watched other people with their lawyers and their folders and their complicated private lives reduced to docket numbers, and I thought about how strange it was that something so enormous, a child, a future, a set of rights that should have been obvious, had to be argued for in a room with fluorescent lighting and institutional carpet. The judge that morning was matter-of-fact in the way that people become when they have seen every possible version of human difficulty. She reviewed the materials. His father's legal team had submitted an affidavit questioning the nature of the relationship. My lawyer submitted our counter-materials, including the envelope and the letter from the meeting in Coal Harbour, which I'd had notarized. The judge looked at the envelope documentation for a moment longer than she looked at anything else. She set a schedule for paternity confirmation and interim support, she said, in the particular neutral tone of someone who has chosen her words carefully. The court notes the contents of Exhibit C and will take them into consideration in the broader context of these proceedings. His father's lawyer, who had been speaking with quiet authority all morning, said nothing for a moment. Then he requested a brief recess. I looked at my lawyer. She was writing in her green notebook. She didn't look up, but the corner of her mouth moved slightly. The paternity test came back in early March. His son was confirmed as the father. He had known it already, of course. We both had. But now the court knew it, and the file knew it, and the argument that had been quietly implied by the other side's delay tactics collapsed entirely. My daughter was born on a Tuesday in April, in the same hospital where I worked, which I found both strange and appropriate. She was 6 pounds 11 ounces, and she had a very serious expression on her face from the first moment, as if she was already assessing the situation and finding it acceptable but complex. I held her, and thought about the envelope in Coal Harbour and the woman I'd been the night I'd stood in my kitchen and read it, and I felt very far from that night, and also very close to it. His son was at the hospital. I want to say that clearly, because it's part of the truth. He was in the waiting area, which was where I'd asked him to be, and I asked the nurse to let him come in after the first hour. He held her carefully and looked at her with an expression I recognized as the beginning of something permanent. Whatever his father had tried to engineer, whatever the envelope had been intended to accomplish, it had not accomplished the erasure of that moment. The final support order came through in June. The court assessed his son's income, including income attributed through a family trust structure that his father had set up years earlier and which my lawyer's financial consultant had traced with, I was told, some satisfaction. Under the federal child support guidelines, combined with the additional discretionary amount the judge ordered given the income level, the monthly payment was substantial, not the $800,000 in a lump sum to disappear. Something ongoing, structured, and permanent. Something that would grow as my daughter grew. His father did not come to the courthouse that day, as far as I know. I didn't look for him. I was focused on my lawyer's voice as she explained the order, on my sister sitting beside me, on the paper in my hands that had my daughter's name on it. There is something I want to say about the money, because I know it's what people think about when they hear a story like this. $800,000 is not an abstract number when you are a nurse in Vancouver paying rent and carrying student debt and trying to build something from scratch. I thought about it seriously. I want to be honest about that. I understood what it would have done for my immediate circumstances. I am not a person who has ever had the luxury of being indifferent to money. But the letter had asked me to agree that the meeting had never taken place. It had asked me to agree that my daughter had no father. It had asked me to take a price for her existence and call it fair. I kept thinking about what I would tell her someday, about what kind of story she would inherit depending on the choice I made. I wanted her to inherit one where her mother had looked at the envelope and set it down and walked out of that boardroom and done something harder and slower and ultimately more permanent. The support isn't symbolic, my lawyer had said in one of our early meetings. In high-income cases, it reflects the standard of living your child would have had access to. It's not charity, it's recognition. I go back to that word sometimes, recognition. His son and I are not together. That chapter closed gently, without a particular moment of rupture. Somewhere in the long months of legal proceedings and new parenthood. He sees our daughter on a regular schedule that we worked out through a parenting coordinator, and he shows up reliably, which I consider a form of character. His father has never contacted me again. I don't know what he tells people about the situation, and I've stopped spending any time imagining it. My daughter is 14 months old now. She has opinions about scrambled eggs and a particular fondness for the ferry to Horseshoe Bay, where we go sometimes on weekend mornings to watch the boats. She points at things constantly, like the world is a catalog of objects she intends to own. I tell her their names: water, boat, mountain, sky. I think sometimes about what it would have meant to take the money and sign the paper. I think about what it would have meant for her to grow up with no legal claim on her father, no recognition from the courts, no number on a document that said, "You exist, you count, someone is accountable to you." I know that money is real and that principle is easy to talk about in the abstract. I also know that I stood in a boardroom in Coal Harbour and was handed an envelope and was expected to be grateful. I know that the man across the table from me had spent a long career solving problems by determining their price, and that he had looked at me and determined mine with complete confidence. I want other women to know that the thing he was most confident about was the thing he got most wrong. The morning after the final order, I took my daughter for a walk along the seawall. It was one of those May mornings in Vancouver when the light comes in low off the water and everything looks provisional and clean, like the city is still deciding what it wants to be. I pushed the stroller and I thought about nothing in particular for a while, which is a thing I have learned to do in the stretches between everything that needs to be dealt with. A woman stopped to look at my daughter. Strangers do this constantly. I've found and said she was beautiful. I said thank you. The woman asked how old she was. I said 14 months. The woman smiled and said, "Enjoy every minute," and then she kept walking. I stood there for a moment on the path with the water to my left and the city behind me, and I thought, yes, that is exactly what I intend to do. There are women who have done this longer and harder than I have, with less support and more at stake, who never had a lawyer or a sister in Burnaby, or a colleague who mentioned the right firm at the right time. I think about them a lot. I think about my mother, who managed on far less than what the court ordered for my daughter, who figured it out week by week, who never once made me feel like a problem that needed solving. That's the other thing his father miscalculated, when he sat across from me in that boardroom and pushed his envelope across the table with the quiet authority of a man who has always been obeyed. He had no idea whose daughter he was dealing with. I don't say that to sound defiant, or to tie things up too neatly. I say it because it's true. I say it because I went home after that meeting and called my sister and lay awake thinking about my mother, and in the morning I made a phone call that cost me nothing but a few minutes, and everything that followed came from that. Not from $800,000. Not from silence. From one phone call, one green notebook, one lawyer who asked me what I wanted to do and waited for my answer. If you are sitting somewhere right now reading your own version of that envelope, whether it came in a boardroom or a text message or a conversation you keep replaying, I want you to know that there is a call you can make. In Canada, family law legal aid is available depending on your income and province. Law Society referral services exist. Family law clinics operate at universities and community legal services. The law in this country does not require you to be wealthy to be recognized. Protection is not selfish. Knowing your rights is not aggression. And whatever price someone has decided you are worth, whatever number they've written on a piece of paper and slid across a table, they do not get to determine what you do next. That part belongs to you.